Bharatiya Nagarik Suraksha Sanhita, 2023. Chapter 9. Security for keeping the peace and for good behavior. 125. Security for keeping peace on conviction. 1. When a court of session or court of a magistrate of the first class convicts a person of any of the offences specified in subsection 2, or of abetting any such offence and is of opinion that it is necessary to take security from such person for keeping the peace, the court may, at the time of passing sentence on such person, order him to execute a bond or bail bond, for keeping the peace for such period, not exceeding 3 years, as it thinks fit. 2. The offences referred to in subsection 1 are any offence punishable under Chapter 11 of the Bharatiya Nyaya Sanhita, 2023. Other than an offence punishable under subsection 1 of Section 193 or Section 196 or Section 197 thereof. B. Any offence which consists of, or includes, assault or using criminal force or committing mischief. C. Any offence of criminal intimidation. D. Any other offence which caused, or was intended or known to be likely to cause, a breach of the peace. 3. If the conviction is set aside on appeal or otherwise, the bond or bail bond so executed shall become void. 4. An order under this section may also be made by an appellate court or by a court when exercising its powers of revision. Back to Index 126. Security for keeping peace in other cases. 1. When an executive magistrate receives information that any person is likely to commit a breach of the peace or disturb the public tranquility or to do any wrongful act that may probably occasion a breach of the peace or disturb the public tranquility and is of opinion that there is sufficient ground for proceeding, he may, in the manner hereinafter provided, require such person to show cause why he should not be ordered to execute a bond or bail bond for keeping the peace for such period, not exceeding 1 year, as the magistrate thinks fit. 2. Proceedings under this section may be taken before any executive magistrate when either the place where the breach of the peace or disturbance is apprehended is within his local jurisdiction or there is within such jurisdiction a person who is likely to commit a breach of. 127. Security for good behavior from persons disseminating certain matters. 1. When an executive magistrate receives information that there is within his local jurisdiction any person who, within or without such jurisdiction, either orally or in writing or in any other manner, intentionally disseminates or attempts to disseminate or abets the dissemination of any matter the publication of which is punishable under Section 152 or Section 196 or Section 197 or Section 299 of the Bharatiya Nyaya Sanhita, 2023, or b. Any matter concerning a judge acting or purporting to act in the discharge of his official duties which amounts to criminal intimidation or defamation under the Bharatiya Nyaya Sanhita, 2023. E. Makes, produces, publishes or keeps for sale, imports, exports, conveys, sells, lets to hire, distributes, publicly exhibits or in any other manner puts into circulation any obscene matter such as is referred to in section 294 of the Bharatiya Nyaya Sanhita, 2023. And the magistrate is of opinion that there is sufficient ground for proceeding, the magistrate may, in the manner hereinafter provided, require such person to show cause why he should not be ordered to execute a bond or bail bond, for his good behavior for such period, not exceeding 1 year, as the magistrate thinks fit. 2. No proceedings shall be taken under this section against the editor, proprietor, printer or publisher of any publication registered under, and edited, printed and published in conformity with the rules laid down in the Press and Registration of Books Act 1867, 25 of 1867, with reference to any matter contained in such publication except by the order or under the authority of the state government or some officer empowered by the state government in this behalf. 128. Security for good behavior from suspected persons. When an executive magistrate receives information that there is within his local jurisdiction a person taking precautions to conceal his presence and that there is reason to believe that he is doing so with a view to committing a cognizable offense, the magistrate may, in the manner hereinafter provided, require such person to show cause why he should not be ordered to execute a bond or bail bond for his good behavior for such period, not exceeding 1 year, as the magistrate thinks fit. 129. Security for good behavior from habitual offenders. When an executive magistrate receives information that there is within his local jurisdiction a person who a. is by habit a robber, housebreaker, thief, or forger, or b. is by habit a receiver of stolen property knowing the same to have been stolen, or c. habitually protects or harbors thieves, or aids in the concealment or disposal of stolen property, or d. habitually commits, or attempts to commit, or abets the commission of, the offense of kidnapping, abduction, extortion, cheating or mischief, or any offense punishable under Chapter 10 of the Bharatiya Nyaya Sanhita, 2023, or under Section 178, Section 179, Section 180 or Section 181 of that Sanhita, or a. habitually commits, or attempts to commit, or abets the commission of, offenses involving a breach of the peace, or f. habitually commits, or attempts to commit, or abets the commission of I. any offense under one or more of the following acts, namely a. the Drugs and Cosmetics Act, 1940, 23 of 1940, b. the Foreigners Act, 1946, 31 of 1946. C. The Employees Provident Fund and Miscellaneous Provisions Act, 1952, 19 of 1952. D. The Essential Commodities Act, 1955, 10 of 1955. A. The Protection of Civil Rights Act, 1955, 22 of 1955. F. The Customs Act, 1962, 52 of 1962. G. The Food Safety and Standards Act, 2006, 34 of 2006, or e. any offense punishable under any other law providing for the prevention of hoarding or profiteering or of adulteration of food or drugs or of corruption, or g. is so desperate and dangerous as to render his being at large without security hazardous to the community, such magistrate may, in the manner hereinafter provided, require such person to show cause why he should not be ordered to execute a bail bond, for his good behavior for such period, not exceeding 3 years, as the magistrate thinks fit. 130. Order to be made. When a magistrate acting under Section 126, Section 127, Section 128 or Section 129, deems it necessary to require any person to show cause under such section, he shall make an order in writing, setting forth the substance of the information received, the amount of the bond to be executed, the term for which it is to be in force and the number of sureties. After considering the sufficiency and fitness of sureties. 131. Procedure in respect of person present in court. If the person in respect of whom such order is made is present in court, it shall be read over to him, or, if he so desires, the substance thereof shall be explained to him. 132. Summons or warrant in case of person not so present. If such person is not present in court, the magistrate shall issue a summons requiring him to appear, or, when such person is in custody, a warrant directing the officer in whose custody he is to bring him before the court. Provided that whenever it appears to such magistrate, upon the report of a police officer or upon other information, the substance of which report or information shall be recorded by the magistrate, that there is reason to fear the commission of a breach of the peace, and that such breach of the peace cannot be prevented otherwise than by the immediate arrest of such person, the magistrate may at any time issue a warrant for his arrest. 133. Copy of order to accompany summons or warrant. Every summons or warrant issued under Section 132 shall be accompanied by a copy of the order made under Section 130. And such copy shall be delivered by the officer serving or executing such summons or warrant to the person served with, or arrested under, the same. 134. Power to dispense with personal attendance. The magistrate may, if he sees sufficient cause, dispense with the personal attendance of any person called upon to show cause why he should not be ordered to execute a bond for keeping the peace or for good behavior, and may permit him to appear by an advocate. 135. Inquiry as to truth of information. 1. When an order under Section 130 has been read or explained under Section 131 to a person present in court, or when any person appears or is brought before a magistrate in compliance with, or in execution of, a summons or warrant, issued under Section 132, the magistrate shall proceed to inquire into the truth of the information upon which action has been taken, and to take such further evidence as may appear necessary. 2. Such inquiry shall be made, as nearly as may be practicable, in the manner hereinafter prescribed for conducting trial and recording evidence in summons cases. 3. After the commencement, and before the completion, of the inquiry under subsection 1, the magistrate, if he considers that immediate measures are necessary for the prevention of a breach of the peace or disturbance of the public tranquility or the commission of any offense or for the public safety, may, for reasons to be recorded in writing, direct the person in respect of whom the order under section 130 has been made to execute a bond or bail bond for keeping the peace or maintaining good behavior until the conclusion of the inquiry, and may detain him in custody until such bond or bail bond is executed or, in default of execution, until the inquiry is concluded, provided that no person against whom proceedings are not being taken under section 127, section 128, or section 129 shall be directed to execute a bond or bail bond for maintaining good behavior. B. The conditions of such bond, whether as to the amount thereof or as to the provision of sureties or the number thereof or the pecuniary extent of their liability, shall not be more onerous than those specified in the order under section 130. 4. For the purposes of this section, the fact that a person is a habitual offender or is so desperate and dangerous as to render his being at large without security hazardous to the community may be proved by evidence of general repute or otherwise. 5. Where two or more persons have been associated together in the matter under inquiry, they may be dealt with in the same or separate inquiries as the magistrate shall think just. 6. The inquiry under this section shall be completed within a period of 6 months from the date of its commencement, and if such inquiry is not so completed, the proceedings under this chapter shall, on the expiry of the said period, stand terminated unless, for special reasons to be recorded in writing, the magistrate otherwise directs. Provided that where any person has been kept in detention pending such inquiry, the proceeding against that person, unless terminated earlier, shall stand terminated on the expiry of a period of 6 months of such detention. 7. Where any direction is made under subsection 6, permitting the continuance of proceedings, the sessions judge may, on an application made to him by the aggrieved party, vacate such direction if he is satisfied that it was not based on any special reason or was perverse. 136. Order to give security. If, upon such inquiry, it is proved that it is necessary for keeping the peace or maintaining good behavior, as the case may be, that the person in respect of whom the inquiry is made should execute a bond or bail bond, the magistrate shall make an order accordingly. Provided that no person shall be ordered to give security of a nature different from, or of an amount larger than, or for a period longer than, that specified in the order made under section 130. B. The amount of every bond or bail bond shall be fixed with due regard to the circumstances of the case and shall not be excessive. C. When the person in respect of whom the inquiry is made is a child, the bond shall be executed only by his sureties. 137. Discharge of person informed against. If, on an inquiry under Section 135, it is not proved that it is necessary for keeping the peace or maintaining good behavior, as the case may be, that the person in respect of whom the inquiry is made should execute a bond, the magistrate shall make an entry on the record to that effect. And if such person is in custody only for the purposes of the inquiry, shall release him, or, if such person is not in custody, shall discharge him. 138. Commencement of period for which security is required. 1. If any person, in respect of whom an order requiring security is made under Section 125 or Section 136, is at the time such order is made, sentenced to, or undergoing a sentence of imprisonment. The period for which such security is required shall commence on the expiration of such sentence. 2. In other cases such period shall commence on the date of such order unless the magistrate, for sufficient reason, fixes a later date. 139. Contents of bond. The bond or bail bond to be executed by any such person shall bind him to keep the peace or to be of good behavior, as the case may be, and in the latter case the commission or attempt to commit, or the abatement of, any offense punishable with imprisonment, wherever it may be committed, is a breach of the bond or bail bond. 140. Power to reject sureties. 1. A magistrate may refuse to accept any surety offered, or may reject any surety previously accepted by him or his predecessor under this chapter on the ground that such surety is an unfit person for the purposes of the bail bond, provided that before so refusing to accept or rejecting any such surety, he shall either himself hold an inquiry on oath into the fitness of the surety, or cause such inquiry to be held and a report to be made thereon by a magistrate subordinate to him. 2. Such magistrate shall, before holding the inquiry, give reasonable notice to the surety and to the person by whom the surety was offered, and shall, in making the inquiry, record the substance of the evidence adduced before him. 3. If the magistrate is satisfied, after considering the evidence so adduced either before him or before a magistrate deputed under subsection 1, and the report of such magistrate, if any, that the surety is an unfit person for the purposes of the bail bond, he shall make an order refusing to accept or rejecting, as the case may be, such surety and recording his reasons for so doing. Provided that before making an order rejecting any surety who has previously been accepted, the magistrate shall issue his summons or warrant, as he thinks fit, and cause the person for whom the surety is bound to appear or to be brought before him. 141. Imprisonment in default of security. 1a. If any person ordered to give security under Section 125 or Section 136 does not give such security on or before the date on which the period for which such security is to be given commences, he shall, except in the case next hereinafter mentioned, be committed to prison, or, if he is already in prison, be detained in prison until such period expires or until within such period he gives the security to the court or magistrate who made the order requiring it. B. If any person after having executed a bond or bail bond for keeping the peace in pursuance of an order of a magistrate under section 136, is proved to the satisfaction of such magistrate or his successor in office, to have committed breach of the bond or bail bond, such magistrate or successor in office may, after recording the grounds of such proof, order that the person be arrested and detained in prison until the expiry of the period of the bond or bail bond, and such order shall be without prejudice to any other punishment or forfeiture to which the said person may be liable in accordance with law. 2. When such person has been ordered by a magistrate to give security for a period exceeding 1 year, such magistrate shall, if such person does not give such security as aforesaid, issue a warrant directing him to be detained in prison pending the orders of the sessions judge, and the proceedings shall be laid, as soon as conveniently may be, before such court. 3. Such court, after examining such proceedings and requiring from the magistrate any further information or evidence which it thinks necessary, and after giving the concerned person a reasonable opportunity of being heard, may pass such order on the case as it thinks fit, provided that the period, if any, for which any person is imprisoned for failure to give security shall not exceed 3 years. 4. If security has been required in the course of the same proceeding from 2 or more persons in respect of any one of whom the proceedings are referred to the sessions judge under subsection 2. Such reference shall also include the case of any other of such persons who has been ordered to give security, and the provisions of subsections 2 and 3 shall, in that event, apply to the case of such other person also, except that the period, if any, for which he may be imprisoned, shall not exceed the period for which he was ordered to give security. 5. A sessions judge may in his discretion transfer any proceedings laid before him under subsection 2 or subsection 4 to an additional sessions judge, and upon such transfer, such additional sessions judge may exercise the powers of a sessions judge under this section in respect of such proceedings. 6. If the security is tendered to the officer in charge of the jail, he shall forthwith refer the matter to the court or magistrate who made the order, and shall await the orders of such court or magistrate. 7. Imprisonment for failure to give security for keeping the peace shall be simple. 8. Imprisonment for failure to give security for good behavior shall, where the proceedings have been taken under section 127, be simple, and where the proceedings have been taken under section 128 or section 129, be rigorous or simple as the court or magistrate in each case directs. 142. Power to release persons imprisoned for failing to give security. 1. Whenever the district magistrate in the case of an order passed by an executive magistrate under section 136, or the chief judicial magistrate in any other case is of opinion that any person imprisoned for failing to give security under this chapter may be released without hazard to the community or to any other person, he may order such person to be discharged. 2. Whenever any person has been imprisoned for failing to give security under this chapter, the High Court or Court of Session, or, where the order was made by any other court, district magistrate. In the case of an order passed by an executive magistrate under Section 136, or the Chief Judicial Magistrate in any other case, may make an order reducing the amount of the security or the number of sureties or the time for which security has been required. 3. An order under subsection 1 may direct the discharge of such person either without conditions or upon any conditions which such person accepts, provided that any condition imposed shall cease to be operative when the period for which such person was ordered to give security has expired. 4. The state government may prescribe, by rules, the conditions upon which a conditional discharge may be made. 5. If any condition upon which any person has been discharged is, in the opinion of district magistrate, in the case of an order passed by an executive magistrate under Section 136, or the Chief Judicial Magistrate in any other case by whom the order of discharge was made or of his successor, not fulfilled, he may cancel the same. 6. When a conditional order of discharge has been cancelled under subsection 5, such person may be arrested by any police officer without warrant, and shall thereupon be produced before the district magistrate, in the case of an order passed by an executive magistrate under Section 136, or the Chief Judicial Magistrate in any other case. 7. Unless such person gives security in accordance with the terms of the original order for the unexpired portion of the term for which he was in the first instance committed or ordered to be detained, such portion being deemed to be a period equal to the period between the date of the breach of the conditions of discharge and the date on which, except for such conditional discharge, he would have been entitled to release, district magistrate, in the case of an order passed by an executive magistrate under Section 136, or the Chief Judicial Magistrate in any other case may remand such person to prison to undergo such unexpired portion. 8. A person remanded to prison under subsection 7 shall, subject to the provisions of Section 141, be released at any time on giving security in accordance with the terms of the original order for the unexpired portion aforesaid to the court or magistrate by whom such order was made, or to its or his successor. 9. The High Court or Court of Session may at any time, for sufficient reasons to be recorded in writing, cancel any bond for keeping the peace or for good behavior executed under this chapter by any order made by it, and district magistrate. In the case of an order passed by an executive magistrate under Section 136, or the Chief Judicial Magistrate in any other case may make such cancellation where such bond was executed under his order or under the order of any other court in his district. 10. Any surety for the peaceable conduct or good behavior of another person ordered to execute a bond under this chapter may at any time apply to the court making such order to cancel the bond and, on such application being made, the court shall issue a 143 Security for unexpired period of bond. 1. When a person for whose appearance a summons or warrant has been issued under the proviso to subsection 3 of Section 140 or under subsection 10 of Section 142 appears or is brought before the magistrate or court, the magistrate or court shall cancel the bond or bail bond executed by such person and shall order such person to give, for the unexpired portion of the term of such bond, fresh security of the same description as the original security. 2. Every such order shall, for the purposes of sections 139 to 142, both inclusive, be deemed to be an order made under Section 125 or Section 136, as the case may be.